This material, presented by an external source, includes general commentary for informational purposes only and is not legal or professional advice. There may be risks associated with relying or acting upon this information, and listeners should seek qualified professional or legal counsel before doing so.
If you asked most leaders what makes compliance so difficult right now, I would bet money that they would not point to just one law or one major policy shift. It's the buildup of everything. Different rules in different states, new requirements layered onto old ones, and for organizations operating across multiple jurisdictions, that challenge becomes even harder. And suddenly, compliance is not just a legal issue. It becomes a question of systems, handoffs, communication, and whether the organization can line up its efforts to hit a moving target. So today we're talking about the current employment law landscape, where risk is rising the fastest and what leaders should be paying attention to as they build more resilient, scalable practices for the road ahead. To have this conversation, I had to call in an expert in employment law. And that's Chris Olmsted, managing shareholder of Ogletree Deakins San Diego office. Chris advises employers on compliance and complex workplace risk. He's spent decades helping organizations navigate fast-changing labor and employment issues. And today he's here to help us make sense of what's shifting and what leaders should do next. Hi, Chris. Welcome. You may already know what question is coming, but I have to ask it because I ask it at the beginning of every podcast. This podcast is called When Work Works. So can you fill in the blank for us? Work works when?
I think work works when you don't have to call your lawyer every day to figure out what you did wrong. And as an employment law attorney, I get those calls all the time, and I'm always happy to help our clients. But a lot of times we're seeing that issues should have been tackled maybe on the front end with more effort on compliance. So I think work works when employees have clarity on clear expectations, clear rules, clear processes for resolving disagreements.
When we're looking at the employment law landscape, what feels most different or complicated from your perspective right now?
What's new and emerging is just the sheer volume and velocity of change at the state and local levels that we've seen these recent years more than ever. So we used to just talk about a handful of states with distinct employment laws. So California, where I'm seated, that was the number one on the list. It's like, California is crazy, compliance there is insane, but the rest of the world, not so much. Well, you'd throw in New York and Massachusetts every once in a while, but now there's dozens of states that are approaching California's level of complexity. So that's different than in past years where there were a few outlier states that we just needed to be really careful about, but everywhere else we just get through it. So pay transparency is a perfect example. So there's laws in Illinois and Minnesota, New Jersey, and Vermont, and Massachusetts that took effect this last year, 2025, and going into 2026. Each with slightly different requirements, annoyingly different compliance obligations. And so that's sort of emblematic of what we're facing these days is compliance obligations in multiple states that don't align with each other, giving headaches to the HR department, causing them to go on cruises and try and forget it all.
and payroll too, right? I mean,
payroll too. Let's not forget them.
Payroll folks are going through it. They're a whole other group. I've been in front of a lot of payroll professionals recently as well. And the pace of change for them, is just crazy, from a compliance perspective. And, I also want to caution, you mentioned a lot of states there, but if we didn't mention your state, that doesn't mean that there's not compliance concerns there, because certainly, your state, definitely has its own, no matter where you are. As we move forward, a big theme in your work is that employers are really no longer responding to just one clear national standard. And you were mentioning it would be easy if we all were under the same set of rules. Can you help us understand how that patchwork of state and local rules show up inside organizations when they try to keep compliance up to standard, especially for multi-state employers who try to create consistency across the business? I imagine consistency through all the change is one of the things that's more difficult to attain. Is that fair to say?
My experience with multi-state employers is they often discover their gaps when something goes wrong. There's a complaint, there's an audit, there's a lawsuit, and then there's a realization in hindsight, oh, this is a blind spot for us. We didn't adequately address that. And so that's unfortunate. In today's complicated world, it's almost inevitable. Colorado, for example, is stricter than most states on the job posting transparency requirements. And if an employer decides, well, we're just going to have a consistent plan where it's whatever the state has the most rigid standards, will comply with that, then it may be challenging across the board to comply. So a lot of employers are deciding, well, in some states we're going to be this way, in other states we're going to be that way. So organizationally, compliance ends up being sort of fragmented between HR and legal and IT and payroll without someone really owning the big picture altogether. So I think the bottom line is, with this increasing multi-state complexity, is those teams need to unify and talk to each other. Someone needs to own the issues so that it's not just different departments pointing at each other and saying, well, that's your territory. That's not our problem.
It's interesting. I talk a lot about silos and how we need to really work to remove silos, but it's not just that. It's also gatekeeping information. If one part of the organization learns something that could benefit another part of the organization, why not have a way to share that, especially when it comes to something as important as compliance? And what I find so often is that, you'll have people who are at an organization for, a long period of time. They're used to doing things one way, and then a new rule will come down the pike, and, they'll learn about it and they'll implement it, but they won't tell their counterparts. They won't tell another area of the organization. And that just doesn't compute for continuity and also for compliance.
Yes, Julie, that's a really good point. I agree that's a struggle for a lot of organizations.
Yeah, siloing itself, especially with HR and payroll, and HR is closer now to finance than it's ever been. Should be closer to legal than it's ever been as well. And I also think, you mentioned something there about being reactive rather than proactive. Having real-time insights with the HR technology that people have, and partnering with organizations that are able to provide HR and payroll professionals with updates about compliance, I think is also incredibly important, because that's the other thing. It's just hard to keep up with all the changes, especially when you are a multi-state workplace. Where do you think organizations are sort of still underestimating just how quickly this landscape is moving forward and evolving? And what are some of the downstream consequences of not working in real time, right? Or not adapting sooner rather than later?
So I'm seeing mixed results across our clientele. So there are some organizations that always seem to be one or two legislative cycles behind where things are now. And by the time they update their policies or processes for laws that passed last year, they're already behind because there's a new legislative cycle coming at us that are changing things for the coming year. There's some immediate compliance concerns that they need to address, but they don't tackle them soon enough. An example would be in California, there's a new law, AB 692, which is prohibiting some sorts of agreements that require employees to repay monies that are paid to them if they are terminated or quit the company. So you get a sign-on bonus, and if you leave the company before the stated time, you have to pay back the money. So in California, as of the start of this year, those sorts of agreements either became unlawful or in some cases allowed, but subject to very specific compliance requirements. So there's a lot of businesses out there that haven't caught on to this. They're not yet updating their sign-on bonuses and other agreements, educational benefit agreements. And so here we are 4 months into the year, and they're already 4 months behind and setting themselves up for vulnerability. Another big area that I mentioned a moment ago is the AI regulations coming at us. So I think that's coming very quickly. Just AI in general is coming at us very quickly. I don't think society as a whole is really ready for the technology that's coming, and companies are no different as far as the legislative efforts to regulate it and anticipating what's coming at us. For example, in California next year, 2027, there's going to be a whole new regulatory framework coming out, and businesses that wait until 2027 to figure that out, as opposed to getting a head start on it now, I think they're just going to always be behind. So that's the struggle. Keep pedaling the bicycle and keep up with the pack, so to speak, with the pack being the legislature and the government agencies that are rapidly putting out regulations in new spaces.
So many organizations are moving quickly with AI, and AI itself and the advancements in that technology are moving quickly. What are you watching most closely when it comes to AI, particularly in hiring and promotion and other employment decisions? Because AI tools themselves, that's one thing, but then using those tools to make decisions is a whole other animal. What's your take there?
So my take is that companies are adopting AI resources more quickly than they have time to structure and vet the applications. So we have employees almost on a rogue basis, just, I'm going to use ChatGPT to do this thing, and I've got a bunch of resumes I don't have time to review, so I'm just going to throw it into this AI thing, and AI can tell me who I should interview and hire. And that's a huge mistake. That's going to come back and burn the company ultimately. And then not to mention that if you don't have the right AI system, you're feeding a bunch of your corporate intel into AI, and that might somehow be amalgamated into its model somehow, that your information is getting out there through that process. When you throw something into AI, is it really confidential or protected? The answer may be no.
Generally no, unless you as an organization pay for an enterprise license. And I agree with you on that. I tell folks, listen, AI is becoming so ingrained in our everyday life. If you don't provide your employees the tools to do those kind of things in a safe manner, then they're going to do them anyway in a non-safe manner because we've gotten so used to utilizing these tools. But I digress.
Absolutely.
Yeah.
So we've got Colorado as an example. They've got an AI act that's effective this year, just a month or two ago, has some very rigorous standards. Illinois is getting into the act with its Human Rights Act that was effective at the start of this year to treat AI-driven discrimination in recruiting and hiring and promotion and discipline and discharge as a human rights violation under its law. New York City has its own local regulations. And as I mentioned, California has just rolled out some updated regulations that are going to impose some heavy obligations on employers that use those automated decision-making processes at work. So again, don't just jump into the pool and figure out, we're going to figure out how to swim in this. I think you got to take those swimming lessons first, figure out what those regulations are, especially in the states I've named, and just make sure that you have a structured, organized approach. That might mean slowing down a little bit and not using AI as quickly as the tools become available. But the dividends will be paid down the road when you've got an organized, structured approach that's not going to get you into regulatory hot water.
It's not that you have to be first to utilize these tools. It's that you have to get it right, and put, parameters around their usage and ensure that people, know what they can and can't be putting into, these really powerful tools, which are great, right? When utilized the right way. And then I think about like that promotion piece, right? Imagine your employer utilizing an AI tool that can definitely get things wrong here and there, right? That's why, you can't rely on those large language models specifically for that. Having good HR technology with built-in AI capability, I think, is really the way to go. And from a compliance perspective.
If you look at the California regulations, an example is there's really a motivation to include a human element in any decision-making process. So the regulations don't prohibit the use of AI, but some of the more onerous disclosure processes and compliance processes are relieved when there's sort of a human being overseeing the process and ready to override something that AI is doing where appropriate.
I want to take a minute to ground this conversation in one example that really captures how quickly this landscape is moving, and it's something that Chris mentioned. Welcome to This Week in HR, where I share a piece of news tied to the conversation that we're having. So let's look at Colorado for a second, as the state's new act on artificial intelligence is being watched pretty closely right now. And that's because the rules are still taking shape in real time. Originally, this act was expected to take effect earlier, but after some pushback, it was delayed to June 30th, 2026. Now, a working group has put forward a proposal that could significantly change what employers are actually required to do under the act. Some of the more burdensome obligations could be scaled back, while other parts of the proposal would broaden the kinds of tools that fall under scrutiny in the first place. When it comes to transparency in pay practices, right, why has that become such a major pressure point for employers in your view?
Pay transparency laws have multiplied faster than, in my view, almost any other kind of regulatory or legislative laws out there. By this year or the end of this year, a large share of U.S. employees will be covered by some form of pay range disclosure requirement or pay transparency laws. In my mind, there's really, to try and organize it all in someone's head, there's kind of 5 distinct areas of laws. So there's salary history bans, meaning don't ask your job applicants what they have been earning at other jobs. There's several states that regulate that. Pay ranges in job postings is another big piece, so salary ranges. Disclosures to applicants on request of the pay range, disclosures to current employees on request to the pay range applicable to their job. And then finally, the aggregate pay data reporting to the state in places such as California, where there's an annual reporting obligation. And so the challenge to employers, just like in the other areas we've been discussing, is there's no 2 laws that are identical. The other struggle for employers in this space is deciding, most of the laws say, well, you got to post a good faith range. So if you got a job, you're likely to pay someone $60,000 but your pay range is $30,000 to $100,000 or $150,000. Is that really good faith? Because who are you really going to pay at the lower end and the higher end? Are you just being lazy and saying, well, it's somewhere in there? You'll know when we give you a job offer. And so there hasn't been a lot of regulatory agency pushback or litigation on this point so far. I think the struggle at this point is just getting everyone to post those salary ranges. But I expect agencies and attorneys who file lawsuits are going to get around to challenging employers who don't really have a good faith range. So all these issues are challenging for employers in the transparency environment we're in, where these numbers have to be disclosed.
Speaking of pay and pay practices, regarding wage and hour laws, you called out wage and hour laws as an area that we should watch. And I think that's one that can get really complicated quickly across a lot of jurisdictions. From your view, what are the biggest changes or pressure points that HR leaders should have on their radar right now from a wage and hour law perspective?
So there's a few things on my list. First of all, independent contractor classification remains a major issue in multiple jurisdictions. The federal standards seem to be shifting backwards a bit, but states are filling in the void. We have a few states that have been very rigorous. California, Massachusetts, New Jersey have aggressive tests. I'm mentioning the same likely suspects, but I think other states are going to jump into the fray as well. And I expect that independent contractor classifications are going to be increasingly challenging in multiple jurisdictions. So I think employers would do well to get ahead of that, really look at the standards that are emerging in different states and maybe revisiting whether the independent contractor relationships are really working for the organization. Predictive scheduling is something that is emerging in a few limited jurisdictions. So we've got Chicago and Philadelphia and Oregon and a few areas in Northern California, but I can see that emerging as well, as far as the ability to schedule employees on short notice or changing their scheduling and then having to pay premiums if those schedules are altered. And another area I'm seeing, as always, California is a dangerous place when it comes to wage and hour law. There's been a lot of talk about the reform to California's wage and hour law. It's so-called PAGA law, or its Private Attorney General Act, remains a very huge issue in California. There's a huge amount of litigation. Some employers are saying, well, didn't they reform that law? And therefore, can we just ease off our compliance efforts? Because we're not going to see as many PAGA lawsuits. And to the contrary, we see an ongoing upward trend on those lawsuits being filed. Interestingly, there are new tools that employers can use to avoid or reduce their penalties in the context of compliance, but that goes back to being proactive. It's not what you did after the lawsuit was filed or the notice was given by the lawyers, but what you did in preparation for that to keep your compliance at the highest level possible. That's where the PAGA liability will drop the most if those efforts are undertaken ahead of time.
So much to unpack here. And another piece of the puzzle, this employment puzzle, is the leave management and accommodations, right? Where are they getting tripped up there today as requirements continue to expand across jurisdictions and federally and whatnot?
So there's always been that struggle with employers trying to comply with multiple different leave laws. So we've got the FMLA at the federal level, and then a lot of states have their own version of FMLA. For example, California has its California Family Rights Act, which is similar but not identical to the FMLA. Then we've got ADA accommodation leaves. We got the Pregnant Workers Fairness Act that's a few years old at this point. And then a lot of new state leave laws have come online. So there's Minnesota's Paid Family Leave Act that just started this year. Again, it's a little bit different than FMLA. Delaware has one that's coming online as well. And then just the good old-fashioned compliance puzzles that relate to someone who's used up their statutory 12 weeks of FMLA leave, but they're still disabled, and under the ADA, there may be a reasonable accommodation needed for employees to receive additional leave. And then complicating things recently there's this remote work concept that we've all sort of dived into during the pandemic and afterwards. So we got to get people back into the workplace. But on the other hand, having gone through the pandemic, we can't necessarily rule out that working from home is completely impossible for certain types of jobs. So that's the new struggle these days, is that employees know that they can ask for reasonable accommodation, remote work, and then employers are struggling to come up with a good compliance framework to respond to those requests.
And how do they do it? I mean, what is it? Obviously, it's case by case, right? And I know there's no cookie cutter answer to that. But if someone were to come to an employer with a request like that, what's the first thing? Call an attorney? Is that the first thing they should do? Yeah.
Well, that's always a good answer in my book. I think calling an attorney early and often will help. But I think what an employer needs to focus on is, first of all, disposing with the concept that, well, we don't allow work from home. Because when it comes to reasonable accommodation, it's not a question of whether it's against the rules. It's a question of, can this person perform their essential functions of their job? And a lot of times what happens is the employer overlooks that we could adjust some of the environmental configurations at work to address the person's limitations. So if they say, I can't work under fluorescent lights, we can change the light bulbs. If they say, I can't work in a noisy environment, we can give them a quieter office. Those things can be adjusted at work, and we might be able to accommodate someone in a way that allows them to do their job at work. And then the number two, I think in some instances, employers just need to acknowledge that, at least to some extent, employees may need to work from home on some basis because of a disability if the limitations can't be accommodated at work. And so I think we just need to step away from a rigid rule that says we never allow people to work from home, because that will not work under the current ADA accommodation framework. So that would be my advice to employers, is just re-examine the rules for remote employment accommodation and ensure that you're going through a deliberative process rather than just closing the door on any consideration of remote work.
Yeah, especially for like frontline workers who can't really work remotely. What do you do, right? I mean,
exactly. So in that case, there may be types of jobs that simply cannot be performed remotely, and therefore an accommodation of working from home is not feasible. They need to be physically present in the workplace to perform their essential jobs. But there's a lot of office roles, for example, where the physical presence is not the essence of the job. That's where the struggle is the administrative or the office type work that could be performed remotely. And then historically in the last 6 years has been performed remotely. So it's harder to say we cannot or will never do that.
When it comes to things like non-competes and restricted covenants, where do you see the biggest risk for employers right now as states really continue to tighten and challenge those agreements?
It's another example of where the federal government is backing off a bit. The FTC's rules have been negated by the court and the agency, but then states are stepping in. Again, California, you've heard that state mentioned several times. Minnesota, even Oklahoma and North Dakota is on my list of notes here. Is really those states, you normally hear them on, compliance issues in the employment law space. I just gave the example earlier on of California's AB 692 that's prohibiting these stay or pay type arrangements. It's seen as a non-compete in that if we make someone repay a bunch of money we gave them in order to leave the company, they're sort of stuck with the company unless they have that money to pay back. We're seeing a few states, in addition to California, New York, for example, is looking at that kind of legislation. And I expect once New York and California go in a certain direction, there's a list of states that like to follow along as well. Texas and Florida are even looking at regulations in this space. Again, 2 states that you wouldn't normally think are, heavy with the legislation are looking at that. So I think the pivot for employers is more towards confidentiality agreements, trade secret hygiene, invention assignment type agreements that are all narrowly tailored to protect the employer's interests, but avoiding the broader swath of you can't go work for a competitor under any circumstances. Those are increasingly being challenged in so far a limited number of jurisdictions, but a growing number of litigation is arising in a few states. So I think that's where employers need to keep the focus.
Things are changing very quickly. And, when we look towards the future, what is it that leaders should be thinking about when they build systems and processes and handoffs between those groups so that things can go a little bit more smoothly when these requirements shift? From your perspective, what would you say are some of the things that should be top of mind?
I think just acknowledging we can't fix everything at once, and we should fix some things sooner. And prioritizing that, I think, is important, because otherwise one becomes overwhelmed and it's just like you kind of throw up your hands and say, well, this is hopeless. This is just a drop in the bucket. How can we address all of that? So start with a jurisdictional inventory. Where do you have people, especially these days we got a few remote people here and then a couple people working in this other state? Just know where people actually are. And then identify those hot spots where we have growing legislation and regulatory environments. Kind of have a heat zone for your map of the U.S. and decide where do we really need to focus our efforts there. Wage and hour looms heavy over a lot of employers, so just know those hot spot states, especially California. And let's make that our goal for 2026 is let's focus on the states where the litigation is raging. Let's focus on that, and we'll get to the other stuff, but let's focus on that.
I love that. Focus on the raging legislation. I love that, by the way.
Yes, right. So, and then fix the systems before you fix the policy. So another problem I see with employers is they get their policies perfectly written and polished. And then when I talk to the employers, if there's something that went sideways, like a lawsuit, it's like, well, yeah, but we never implemented that. We wrote it. The lawyers and HR wrote it to be perfect. And then the people who were supposed to implement it didn't implement it. So now we got a problem of we got policies that say what we're supposed to do, but we're not actually doing what we're supposed to be doing. So that's why I say get your systems in place, the way you're going to actually roll it out, the way you're actually going to ensure compliance, get that out front, and then make sure your policies are in alignment with what you're capable of actually doing in the workplace.
Yeah, I completely agree there. We see that often where folks aren't willing to change a policy or shift a policy, but really the times that we're in require that kind of agility. So we love a good story on this show, and I'm wondering if you have any examples of a team that maybe rose to the challenge of this patchwork world of compliance, or what's going to make teams most successful when navigating these changes? Or how do you measure success? Is it lack of litigation?
I'm thinking of a client who has operations across the U.S., but mostly on the East Coast and West Coast. And so to follow up on the premise I just gave you a moment ago, the focus was, well, let's just make sure everything in California is as in compliance as humanly possible. So the focus was prioritizing California compliance and implementing updates to the payroll system. There were issues where employees were not being paid the proper regular rate of pay because bonuses were being paid, but then they were working overtime and they weren't getting overtime on the bonuses, kind of a complicated, nuanced area. Meal and rest break compliance in California was another big issue. So rather than trying to do a multi-month or even multi-year compliance endeavor, that by the time they got through it all, there's fresh violations that have happened before the fixes were put into place. They looked at the hot spots and tackled those. And they're still working on the other jurisdictions, and they will make some improvements there as well. But I think they've done a lot to kind of lock down their practices very nicely where it matters the most. So I would say that's an example where that has happened. And then in the meantime, they're doing a much better job of having in-house legal and HR in the same room, also with vendors. So they've worked very closely with, for example, their payroll vendors to make sure everything is fine-tuned. Those discussions were not unified before. Legal was talking to HR, and HR was talking to payroll, and payroll was talking to the vendors. But no one was really at the steering wheel of all this to make sure, did we really synchronize everything we needed to synchronize? So that's been improved upon, and the teams are all talking to each other and teaming up project-wise to make sure we're working on this. And then, as importantly, someone is in charge of saying, did we get this over the finish line yet or not? And if we haven't, we're going to keep pushing. Because that was the problem that happened in the past, is they would move down the compliance path, but at some point it would just sort of peter out, and it never really got over the finish line. Oh yeah, we worked on changing the payroll configuration with our vendor, but then some of these never actually got implemented. And so now we're still out of compliance. Anyway, so that's an example of where they sort of learned the hard way, but moving forward, they're, improving on the process. And I think their chances for success in the future are greatly improved at this point.
Yeah, and it is a process, right? You can't fix everything all at once, but you can definitely build awareness and ensure that you're staying on top of things, which I guess brings me to my last question for you. And you've mentioned so many amazing things during this conversation, and I'm blown away by the level of knowledge and just the different complexities that HR and businesses are dealing with today, and just how do they navigate them. So your insights have been amazing. But if you were advising an HR leader, kind of wrapping things up in a bow on how to prepare for the next few years and not just the next few months, is there anything specific that you'd want them focusing on right now?
I'd say build infrastructure, not just policies. There's that's a blind spot, is we have the policies, but not the systems in place. So the organizations that handle the next wave of compliance obligations are the ones that have configurable, auditable systems with jurisdictional settings or logic built in, not the ones that just have the most recently updated handbook. And then secondly, treat employment law compliance as a continuous monitoring function. Assign someone the job of tracking that, interacting with outside counsel, anticipating changes. So what are we seeing in the pipeline for 2027 that we need to start organizing for now? And then I guess the big topic would just stay on top of this AI emergence that we talked about during this session, is that I really think employers need to keep a careful eye on developments and try to start anticipating, number one, in what ways are we going to be adopting AI in our organization? And then number two, what are we seeing on the regulatory front that down the road, if we bring a bunch of AI, it's going to be a struggle to, comply and structure correctly. So let's try and anticipate that and bring in AI into our environment in a way that we're anticipating the way it's going to be controlled and regulated in the future.
Thank you so much for your insights, Chris. Really appreciate you coming on the podcast. And, I learned so much, and I know our listeners did too. So thank you.
Thanks, Julie. It was my pleasure. And I hope to see you on that cruise you're talking about in the future.
Absolutely. We'll be cruising and complying. I want to thank Chris for such an educational conversation. And one thing that really stayed with me is that navigating change well is not just about knowing what's happening. It's about how quickly an organization can respond, how clearly teams can work together, and how willing leaders are to build systems that can adapt as the landscape shifts. Because in a world where expectations, regulations, and risks are constantly evolving, the organizations that will be best positioned are the ones that are flexible, connected, and ready to move. That means breaking down silos between teams, creating stronger handoffs, and ensuring that HR, legal, operations, and IT are not working in parallel, but in partnership. When that happens, organizations are better equipped to respond to what is next without losing consistency, clarity, or trust along the way. Thanks for listening to When Work Works. Follow or subscribe wherever you listen, and we'll see you next time.